Roland Mumford with Mumford.law. If there's not one thing that is more frustrating than receiving a DUI, it's when you find out that a police officer is driving under the influence, allegedly, and then they are let off the hook. I want to discuss three interesting cases in this particular video. One is from back in 2018 that involved a local officer near where I reside. And I was so frustrated by that case and the preferential treatment of how that officer was let off the hook. That officer was clearly intoxicated. He had a .10, and he had a firearm in the vehicle, and he basically got away with it. That prosecutor's office, their spokesperson, said that this was treated like any other case. Well, I can tell you, after representing numerous DUI defendants in that particular county, in that courthouse, with that prosecutor's office, it is extremely rare that citizens who are arrested with a DUI, even with slightly above a .08, do they get reckless driving or do they get off the hook, unless you have a very good lack of probable cause argument for the stop. Now, then in the second video, we'll discuss where a particular officer from the same department was recently pulled over several months ago, but he is being prosecuted. But is it only because he lunged at the officer on scene after telling the officer to cut his body camera off, and the officer refused to do so, doing the right thing? Then the third video is going to be a very recent video, news report, involving a Rhode Island colonel, I believe, a high-level state trooper who's driving all over the interstate. He's being followed by other officers. When they pull over on scene, this high-level officer, I believe, again, a colonel or a high-level Rhode Island state trooper, intimidates them into not arresting him. He's clearly intoxicated, but he is forced into retirement. But he is being prosecuted, but apparently only for reckless driving and another minor charge, and not driving under the influence. Let's take a look at these videos and we'll talk about it. So I was mistaken in my introduction that there may have been a video about this first DUI arrest of a police officer who got away with it. Turns out that Lady Justice is not so blind, in fact. He got preferential treatment, and that is my opinion. I could not find a video on it because it's been about 6-7 years. So I found the article, and this involved a Hendersonville police officer. He will not be prosecuted for DUI charges. His name was Derek Brewer. Now, I was infuriated about this case because back then I was doing DUI defenses, and in this particular county, you cannot get a reckless driving, that is a DUI knocked down to reckless driving, unless you can attack the stop, meaning the lack of probable cause, or you have some other very good argument to support that it should be reduced. I can broadly state that the prosecutors in this county do not lower DUIs, even if it's a .08 or .09, etc. They do not lower them. In fact, I remember a specific prosecutor from this office last year stating, "This is not Nashville, this is Sumner County. In Nashville, you can get DUIs reduced with some possibility. Here, it just does not happen." So this involved Officer Derek Brewer. He was 24. When he was pulled over, he had a gun in the vehicle. According to the affidavit in this article from the Tennessean, the officer could smell alcohol in Brewer's breath. Brewer admitted to consuming 5 Jameson and Red Bull drinks earlier in the evening. Brewer agreed to a field sobriety test and to a breath test. I think that's a mistake in the article. They don't do breath tests here in Sumner County. I'm pretty confident that that was a blood test, which indicated his blood alcohol content was .10, which is over the legal limit of .08. A handgun was found inside the vehicle, according to the affidavit. They had put him on clerical duty after the arrest. He was subjected to a week or two of suspension, not paid, I believe. And the prosecutor here states that the decision to drop the case was made after the prosecutors were assured that Brewer met certain conditions, including that he attend the victim impact panel that Mothers Against Drunk Driving conducts with the courts, and that he attends alcohol safety school, says Steve Hayslip, Director of Communications for the District Attorney's Office. And they say that 3 factors went into consideration. His first offense, the BAC was .10, and the Brewer's service revolver was not voluntarily given back to him, that he would need to file a motion to recover that. I don't know how that makes any sense, because if that was a service revolver, that would have been the property of the Hendersonville Police Department. And this is what is the joke. This was an absolute joke. The ADA says this case was handled no differently than any other first-time offender with a relatively low BAC that faces employment termination from a conviction. If you are convicted of a DUI here, pretty much if you are arrested for a DUI and it is over the .08, you are getting a DUI. You're going to serve 48 hours in jail. You're going to have an interlock device where you got to blow into it to drive your vehicle. You're going to be on probation, pay the fines and costs. You're going to have to pay the more expensive insurance. You're going to technically lose your driver's license, but you'll be put on a limited driver's license where you can drive to work, for food, etc. And then what's interesting here is what the police chief says, Mickey Miller, who I don't have much respect for. He's a former police chief. He was speeding and driving reckless, and we don't want our officers doing things like that. He just conveniently leaves out that this officer was driving drunk. So this is the first video I wanted to discuss to show how a police officer has the advantage of Lady Justice not being blind. Now let's talk about this next video. Same police department. Let's take a look at this news report, and then we'll talk about it on the other side.
A Hendersonville police sergeant has been temporarily decommissioned. He is charged with DUI and assaulting a first responder. Stephen Wilson is accused of driving over 100 miles per hour on a highway. He eventually stopped at a traffic light. A deputy said Wilson had bloodshot, watery eyes, and his car smelled of alcohol. The deputy said Wilson asked him to turn off his body cam. When that deputy refused, he said Wilson tried to grab it. More deputies arrived to take Wilson into custody.
So that's the video that shows this police officer that lunged at an officer trying to cut off the body cam. He had asked the officer to cut off the body cam. And I looked up the criminal disposition and I found it online. This involves Stephen Wilson. He pled guilty to DUI first. His blood alcohol was .220. You have to have an A&D assessment with compliance. Concurrent with resisting arrest, driver's license revoked 1 year, must attend DUI school and victim impact panel, ignition interlock required for 1 year. The previous video where the Hendersonville police officer was arrested with the gun in the vehicle, and I stated to you before I found this document what the deal is that most DUI offenders in this county get, and this is exactly what I stated. So let's take a look at this document. This is what the statute, notice of DUI punishment. Any person who is convicted of first offense shall be fined not less than $350, nor more than $1,500, shall be confined in the county jail or workhouse not less than 48 hours, nor more than 11 months and 29 days, and shall be prohibited from driving in Tennessee for 1 year, provided that if at the time of the offense the alcohol concentration in such person's blood or breath is .20 or more. The minimum jail sentence shall be 7 days instead of 48 hours. So it appears that this officer, with the 10 days, he should have gotten more considering the other charges. He got a deal that a citizen may have gotten. So here, Lady Justice was blind, apparently. Now let's take a look at this story about this Rhode Island trooper who pulls over after swerving all over the road on this highway in Rhode Island. The officers pull him over. The officers give him preferential treatment, put him in the vehicle. But this trooper, he's a colonel, high level. He says, no, I'm driving my vehicle home. You're not going to tow it. And then drives off. And some time had went by. And as you see in this news video, the Attorney General had to find out about it and criticize the preferential treatment that this officer got. And apparently he's only going to be charged with obstruction of justice and reckless driving and not a DUI, because obviously now they don't have the blood alcohol for the proof of the DUI, though I think there was enough. If Rhode Island statute has a appearance and demeanor language in their DUI statute, they probably could have gotten him for steering all over the place on the highway, as you see in the video. He stumbles apparently getting out of the vehicle and other indicators. Let's take a look at this.
Tonight, the Attorney General is criticizing state police over the handling of an investigation into a trooper who drove off from a traffic stop months ago. The I-Team's Brian Crandall is here now. He's been working the story all afternoon. Brian?
Well, Dan, the trooper was forced to quit in May and was charged in court yesterday after he told fellow troopers who pulled him over that he was just going to drive home, and did. State police video shows troopers pulling over a truck that was swerving on I-295 back in March. They quickly identified the driver as 51-year-old trooper Nuno Vasconcelos. The court documents state, and the video shows, troopers talked to Vasconcelos and had him sit in the front seat of a police cruiser. But Vasconcelos then gets out and drives off in his truck. Court documents state Vasconcelos told troopers, using obscenities, that they would not be towing his truck and for them to get back in their cruiser and to follow him home while he drives in a straight line, he said he would do. After looking into the incident, state police say they forced Vasconcelos to retire in May after 20 years on the job. And a supervisor working that night has also retired. Vasconcelos was charged just yesterday with reckless driving and obstructing police. State police say they're disappointed with how the incident was handled, and now the AG's office says it's disappointed in state police for not telling them about it sooner, only finding out through a courthouse conversation just this past Monday plans to have Vasconcelos arraigned. The AG's office saying in a statement this was treated as a simple matter, and it's not, and pointing out that only the AG can prosecute charges brought by state police. The AG saying that is a fact worth remembering, and the AG's office says it will review the matter now. I'm Brian Crandall, NBC 10 News.
Well, I hope you enjoyed these three examples of DUI arrests of police officers. We've seen in the first video where you couldn't get any more preferential treatment. Lady Justice was blind. The second video, the police officer, Lady Justice, was somewhat blind. I think he should have gotten a much more harsh punishment given the circumstances, that at the level of his alcohol, that he tried to have the body camera turned off, that the other officer was recording, and the fact that he was a police officer. He should be held to a higher standard. And in the third video with this Rhode Island trooper, which was very recent, you see that this colonel was forced to retire. We keep hearing this, forced to retire, rather than being terminated and fired. I presume they're forced to retire because they can keep their pensions. I hope you enjoyed this. Thank you for your time. Have a great day.